Well, we say that doctors are the only ones who can police themselves. Lawyers are the only ones who can police themselves. So police are the only ones who can police themselves. So all these different groups think they live in different societies, and that, you know, we wouldn't have needed a constitution if men and women now, I guess the phrase was men, were angels. Maybe you thought whoever said that if men were angels we wouldn't need laws or constitutions. Didn't say men and women because maybe the women were angels. So, it's rare for debaters to put on concise arguments about such important topics, and I'm impressed that they encapsulated the pro and con to 10 minutes. So now we're getting ready for our rebuttals, which are going to be very heated. For our second argument, you're not going to call them rebuttals yet?
Not yet.
All right. I want those rebuttals. How long for the rebuttals? How long for the second argument? I'm the timekeeper. You got to tell me how much time.
We have flexibility. That's a, we got an unstructured debate, so we take as long as we
No, I'm the judge. I want structure.
Well, a couple things, Jim.
You lose points without structure. Sorry.
I would just ask for one thing. If you slow down just a little. It's okay if you lose a little more of your time. Not to put down on the guidance. I want to make sure.
Okay, no problem. We can savor this.
Yes, you can save it.
First off, I want to thank our additional panelists for joining us. Marcel Reed and Chief Deputy Marshal Matthew Fogg. And for the record, I'd like to state that I believe that Jim Murtaugh is biased against my position. And I believe that Zena Crenshaw is stacking the panel. But still, I will persevere.
Mr. McRae, you've now attempted to butter up the judges. Yes. We're going to have to deduct points for those comments. Sorry.
Now, see, what we need is a system of panel accountability.
Yeah.
But anyway, just to moving into the second argument, I want to briefly recap Zena's first argument, which was Attorney Crenshaw's first argument, which is essentially it's a vast right-wing conspiracy. But I'll save my further comments on that for the rebuttal phase, and I'll move into argument number 2. And that is judicial accountability for legitimate but questionable unpopular behavior. It actually defeats more than creates or preserves a fair and impartial judiciary. I mean, think about it. What are decisions that were highly questionable at the time and produced strong public reactions among the citizens and members of Congress? I mean, we all remember Dred Scott, the historic case declaring that Negroes were not citizens, and reinvigorating the Fugitive Slave Act. This case has actually been cited as a stain on the judiciary. More recently, Plessy versus Ferguson, which established separate but equal, and gave basically the green light to Jim Crow and racism, really. It was overruled by Brown versus Topeka Board of Education, which has been widely disparaged from the media for months. So, and then we also had the attempt by Governor Faubus and the Arkansas legislature to ignore and nullify Brown, which occasioned Cooper versus Allen, in which they sent in the National Guard and federal troops to maintain order in Little Rock schools for the rest of the year. I mean, essentially, if the judiciary were subject to the popular will of the people, there have been times when the people weren't right. And so we must still maintain the judicial independence to protect us from that. So again, rather from engaging in social engineering, all Brown did was extend the existing rights of equal protections to a group of citizens that had not enjoyed these rights before. But with little relief coming from Brown and from the other branches of government, what Brown versus Board of Education could not have been decided had there not been an independent and non-subservient judiciary. There was no support for the citizens at that time, and it was only the judges that actually stood up and demanded the rights for all people. So if you had to account to other branches of government answering to questionable but legitimate behavior, it would have defeated the concept and impaired the performance of a fair and impartial judiciary. Aside from Brown and his progeny, a similar argument could be made for certain cases in the 1960s where the Warren Court extended constitutional protections to accused individuals and criminal defendants. I think it's Gideon B. Wainwright established that the right for indigent criminals to have appointed counsel. We have Miranda versus Arizona with its mandatory warnings that we're all familiar about the right to silence and the right for an attorney. Now, these were very highly unpopular decisions, and it took quite some time for the law enforcement community to accept. Although not nearly as unpopular, Matt versus Ohio imposed Fourth Amendment standards on the states through due process clause, the 14th Amendment, and Monroe versus PayPal that police officers could be held liable under 42 U.S.C. Section 1983 for intentional violations of civil rights. Perhaps the point to be made is that these and other decisions could not have been made absent an independent judiciary that did not have to account for legitimate but unpopular behavior when it was doing its job. Some measures suggest that bills introduced in Congress are viewed as infringing on judicial independence. The Judicial Transparency and Ethics Enhancement Act seeks to establish an Inspector General for the federal courts, with the IG possibly acting more of an agent of Congress than anything else. Bills to withdraw jurisdiction from federal courts and for certain types of cases are similarly viewed as infringing upon judicial independence. Arguably, any congressional supervision would compromise judicial independence, make judges subservient to the popular will rather than the rule of law, and cast judges more in the role of politicians trying to appease their constituency. And we can't have politicians as judges.
So Dred Scott is a case supporting the current system?
Well, Dred Scott is an example where the will of the people was for African Americans not to be made holy citizens. And so the court, in following the will of the people, created one of the largest stains on the American judiciary that we've seen. So it's in one sense, while we want the people rule, we don't want model. And so in order to achieve that, the judicial system, the judges, have to be completely independent.
So is your argument the system was broke then, or was working then?
No, my argument is that those judges in basically going on with the popular will of the people made bad choices, which we have now recognized as that case is one of the most memorable.
So the system was broken then, is what you're saying?
Well, what I'm really saying.
It was an exception of the rule. It was an exception of the rule.
Well, in that sense, but I'm just saying that we can't have judges that can't make law, they can't rule by basically public opinion polls, which a lot of times we see politicians acting that way. So even though they were wrong, they were still trying to exercise that type of independence. And as you saw, that case was a problem then, but as we move through time, we've seen cases where they got it right. The will of the people was still wrong, but because they were independent and because they were supported in their independence, they were able to correct the mistakes of the past. It took some time, but we're getting it right. And once again, I'm not arguing that we have a perfect system. I think we have one of the best in the world. And again, if it ain't broke, don't fix it.
Self-policing is not the absence of accountability. It just reflects a choice of who sorts between legitimate and improper behavior. And fortunately, there is a broad diversity that's brought to bear when U.S. judges, legislators, and prosecutors do the sorting and judicial conduct is at issue. Our judges, legislators, and prosecutors emerge under various presidential administrations. They have different ethnic, racial, religious, social, and educational backgrounds. They hail from different geographic areas. Their life and work experiences are different. Public service is what unifies this group. And apparently, that's what's endowing it with this intellectual discipline to disregard popular sentiment and evaluate judges based on law, at least as checked by America's separation of power. So, why is this apparent? Because there is no judicial accountability that judges, legislators, and prosecutors don't allow in America. They are the gatekeepers. And you would think that they have some type of competence, some type of ability in this area that private citizens can't accomplish, can't rival. But we occasionally play our part through jury trials. So let's just ask, can the rule of law ensure due process when it has already been taken down by judicial misconduct, when it has already succumbed to judicial misconduct? Can the rule of law, can due process emerge from the rule of law when the rule of law has already been defeated? Notice the parameters. We have the rule of law, an evaluation of whether it has been violated, and a restoration of the rule when it's been breached. So you got the rule of law, you got an evaluation of whether it has been violated, and then you got a restoration of the rule when it's been breached. As long as the U.S. government divides between executive, legislative, and judicial branches, judges will guard and implement our rule of law. And in doing their jobs, they will at times be praised and at times be criticized. But it's when the criticism of judges escalates to complaints of deliberate, willful, or reckless misconduct that judges should not respond alone for America's judiciary. Restoring the rule of law when it's breached is an obligation of all Americans. So a system for our competent, direct, and effective involvement in every phase of the process is the only balanced response. It is the strategy for judicial oversight that makes the most sense. Of course, the prospect of judges being tried before runaway juries is sure to spark judicial misconduct complaints in a litigious society. And screening those cases through a hospitable fact-finding process is certain to increase the number of complaints that are deemed viable. In fact, judicial misconduct complaints may proliferate before this jury-friendly system corrects itself and settles on what should be prescribed, what should be prohibited. But overall confidence in the judiciary and its independence will survive the shift to a system of judicial oversight that is more based in the involvement of jury trials, or an expansion of the jury's role in the process. Suppressing pools of judicial misconduct complaints is not a proper end in and of itself in a free society. Some good comes from attaining that goal, that is the suppression. The systems that we have now accomplish a tremendous suppression of judicial misconduct complaints. And that, to try to keep the current system in place in order to just keep down the number of judicial misconduct complaints is just simply not a valid goal in our society. But it does accomplish reduced costs and arguably the appearance of justice. If you can report that there's rarely ever a judge guilty of misconduct, perhaps that creates an illusion of justice. It certainly allows job security among judges. And what we have to realize is Americans' founding fathers, they embraced those goals. They embraced those goals. But the constitutional provision is for the good behavior of judges.
We are now going into sudden death rebuttals. And by the way,
We're about to take it to the super delegates.
any more contemptuous remarks about the panel, in your case, will be thrown out for contempt of court.
Sanction.
Who's going to force it?
Washington.
Okay, in rebuttal, the notion that America's processes for judicial oversight are thoroughly corrupted hinges on various perceptions of conspiracies too expansive to consider. I mean, that's why the notion that America's processes for judicial oversight are thoroughly corrupted hinges on various perceptions of conspiracies too expansive to consider, the vast right-wing conspiracies. So perhaps the most widespread judicial scandal in this country was Operation Gaylord, conducted by the FBI and the IRS Criminal Investigations Unit, in which there were over 90 judges on the Circuit Court of Cook County, Illinois, and the chief judge of the Circuit Court cooperated with the investigation. 92 people were indicted, 17 judges, 48 lawyers, 10 deputy sheriffs, 8 policemen, 8 court officials, I guess no marshals, and a member of the legislature. Despite the numerous total of individuals indicted, most judges, most deputy sheriffs, most cops, most lawyers, most court personnel were not involved. I mean, rather than having a vast conspiracy, what was involved were a good many individual instances where bribery and fixing cases carried out between some judges and a few lawyers who knew that the judge could be blocked. A really vast conspiracy that honestly seemed out of the question. Now, part of the problem with conspiracies is that the more conspirators involved, the more likely they are to unravel, and the easier they are to detect. Allegations of very widespread corruption involving many or most judges, several times that many attorneys, a good many law enforcement, and so on. It just seems so quite implausible for at least a few members of such a conspiracy. I mean, someone's bound to get caught. The unraveling of widespread conspiracies is said to increase with the number of conspirators exponentially. But so far, what we seem to get is at best numerous instances of many small conspiracies, as we saw in the Gaylord case. So once again, and final. We have the United States justice system is the envy of the world, and if it ain't broke, don't fix it.
A fifth-rate fiction writer could contrive motive, opportunity, and means to entangle judges in alleged schemes to defraud the courts. But there are judicial outcomes and behaviors that simply defy logic and mathematical probability without at least a possibility of coordinated misconduct. These are fact-sensitive matters within the prerogative of juries. Supreme Court Justice Byron White tells us, even when defendants are satisfied with bench trials, the right to a jury trial very likely serves its intended purpose of making judicial or prosecutorial unfairness less likely. We cannot have a system where the judiciary is the sole and final determinant of whether it has been corrupted. And to invest the obligation of oversight totally in executive and legislative branch officials when to a substantial extent their power is impacted and defined and expanded by the judiciary is a less than adequate solution, even though there may be steps that can be taken that are worthwhile to somehow try to contain judicial discretion. But ultimately, until America involves the people of America in the process of evaluating this judiciary and looking at whether there has been deliberate violations of and abuses of judicial power through the jury trial system, we will not have due process when we attempt to establish judicial misconduct.